In my last video, I talked about when under what circumstances a court might apply what the government considers the dreaded strict scrutiny, right? Where the government would only survive, whatever its policy or program is, would only survive if it was narrowly tailored to achieving a compelling interest. And if you need to brush up on what that means, I'll leave that to my last video. One of the circumstances under which a court would apply this strict scrutiny would be when the government is interfering with the exercise of a fundamental constitutional right. Now, some constitutional rights are listed in the Constitution. Others are not listed in the Constitution, but are inferred, right, from the Constitution's use of words like liberty and privileges and immunities, right, which are very general terms that suggest a sphere of life or a sphere of jurisdiction, right, in a free country where neither the federal government nor any state has jurisdiction, right, where jurisdiction over certain parts of life are reserved to individuals. In fact, the 10th Amendment says, right, the power not delegated to the United States, not given to the United States, the federal government, right, in the Constitution is reserved to the states, comma, or the people, right. It can't be that the state is omnipresent, as Justice Kennedy once said, right, for the Supreme Court. The state cannot be omnipresent in our lives or we don't live in a free country. Now in this video, I want to introduce five rights that the Supreme Court has said are fundamental rights. And five of them that I think are probably going to come out of this pandemic intact, right? So, you know, we're going to find out not only whether we survive coronavirus, right, on an individual basis, but whether certain constitutional rights survive it. And then I'm going to identify three other rights where the court has said that those are constitutional rights, right, fundamental, unenumerated constitutional rights. I'm going to focus on the ones that are not listed here. Right, five that are probably good to go through this, right, but we'll see some of them could be in play, and three that are probably in trouble. The first right that I think is going to come through unscathed is the right to reproduce. Believe it or not, the Supreme Court has held that there is a right among people to reproduce, right, without interference from the government. This comes to us from a decades-old case called Skinner versus Oklahoma, where the state of Oklahoma wanted to sterilize somebody who was a habitual chicken stealer. So if one chicken stealer has more chicken stealers and those chicken stealers have more chicken stealers, the next thing you know, there won't be a chicken in Oklahoma, right, who can feel safe that they won't be purloined before they're tenderloined. Wasn't that cute? In that case, the court came in and said, no. You can't sterilize, right? You can't sterilize people. People have a right to reproduce, right? That certainly is not narrowly tailored, right, to achieving any kind of a compelling interest. So that goes on the list of, ironically enough, we have a list of unlisted rights, right? That goes on the list of unenumerated rights. A related right, and one that might surprise a lot of people, right, comes out of a famous case called Griswold versus Connecticut. And in that case, Connecticut was trying to stop married couples from using contraceptives, right? Even from getting advice about how to use contraceptives from a doctor. And the Supreme Court said no, that there's a fundamental constitutional right to marital privacy, and that includes the use of contraceptives, right? Access and use of contraceptives. You might think to yourself, and it would be a reasonable thing to think to yourself, you know, how could it be that the framers had in mind that contraceptives would be a fundamental constitutional right? Right, liberty, interest, or privilege and immunity, whatever the case may be. You know, it sounds kind of ridiculous. One of the things I always try to encourage people to do when they're thinking about constitutional rights is to flip the question. Because the question is not really whether we as individuals have the right to use contraceptives. The question is really whether the state has jurisdiction over that area, right, of a person's private life. I hope you see the difference. It's one thing to ask, do I have a fundamental constitutional right to access and use contraceptives? The answer to that might be, that sounds kind of stupid, right? But on the other hand, if you ask the question a different way, and this is how courts should be looking at it, the question isn't whether I have an individual right to use contraceptives. The question is who has jurisdiction. Does the state have jurisdiction over that area of life? And this is where the court sort of sometimes says, it gets a little squeamish and says, you know, if the state has jurisdiction over that area of life, it's very difficult to conceive of any area, right, of life where the state would not have jurisdiction. And in a country that's supposed to be free, right, and guaranteed liberty, that seems like it wouldn't be the way to go. So, yes, contraceptive. By the way, in a subsequent case called Eisenstadt, the court went further and said that right belongs not only to married couples but to all consenting adults, right. So reproduction and the related issue of use of contraceptives, access and use of contraceptives, right? Those are fundamental rights. See no reason why those wouldn't come out the other end, right, of this pandemic intact. Okay, next up, the right to get married. Right, that has repeatedly been stressed by the Supreme Court that that is a fundamental right. By the way, I'm filming this in a thunderstorm, so sorry for the rumbling if that comes through the mic. By the way, Lainey, my dog, is very subdued right now. She's over here, right, with her ears back. She hates thunderstorms. She's one of those. Back to marriage. Most famous case, oh, here she comes. Okay, the most famous case, Loving versus Virginia, which of course should have been called Virginia against Loving, if you think about it. Right, the court said it's not up to the state to decide who can marry whom. Right, once again, that is a component of a person's private affairs. That is not the business of the government. So you add that to the list. So now we're up to reproduction, contraceptives, and marriage. To that add what I call the 3 C's. Right, a competent parent, somebody who has not lost custody or given up custody, right, of a child, the court says has a constitutional right to direct the care, custody, and control, which means to take care of their kids, right, to raise them the way the parents want to. There was a case out of Nebraska, probably the most ridiculous case. Well, there were several ridiculous cases, but maybe the most was a case out of Nebraska where somebody was being punished for teaching kids German. Again, the theories underlying some of these laws, right, these old laws, I guess, this was post-World War I. So I guess here the theory was, right, that if kids learn to speak German, they might start thinking in German, and if they start thinking in German, they might start thinking like Germans, and the next thing you know, they wake up every morning with an irresistible impulse to invade France, right, and we can't have that. So, you know, these kind of ridiculous, right, underlying principles, right, underlying some of these laws. But the court says no, it's up to parents to decide what language their kids learn, right, so you can take that further, right. The religion a kid grows up in, right, how the kid gets educated, right, what the kid learns, right, that's all up to parents. Again, doesn't seem like the pandemic would have a lot of impact on that. Finally, there's the issue of family living. Now, this could be an interesting issue. This could conceivably come up here and there. You know, there was a situation in one case where because of a zoning ordinance, a grandmother couldn't live with her 2 grandkids because they were cousins instead of siblings, right? And the court is protective of what it calls the unitary family, right, the family unit, and held that it is not up to the government to decide, right, how many generations can live together or degrees of consanguinity. Has that for a nice legal term, right? Degree of consanguinity, right? I mean, we have a long history, right, tradition in this country of multiple generations living together, aunts and uncles living together, cousins living together. So the court said that's a fundamental right. It's not the government's business. You can, you know, foresee the possibility here, right, with distancing laws and orders and ordinances, whatever, about who has to maintain what kind of distance from whom. If somebody decides to leave one residence and go to another residence, I don't know that any government would really interfere with that if it's family. Certainly if they have a lawyer, they shouldn't. But we'll see. I mean, if any level of government does interfere with that, that would implicate a fundamental right. And again, I don't see courts abandoning that. So that gets us into the 3 constitutional rights that maybe are in a little bit of trouble. And I want to see where courts go with this, and in particular the Supreme Court. The first is abortion. Since Roe versus Wade, the Supreme Court has said that the right of a woman to terminate a pregnancy, at least early in the pregnancy, right before viability, is a fundamental liberty interest that is not under the state's jurisdiction. We see now Texas basically saying no abortion procedure is allowed unless it's necessary to preserve the health of the mother. Right, and so that basically eliminates, right, all what the courts, what the Fifth Circuit and the state are calling, right, elective abortions, right, not necessary for health, but because the woman wants to not have a child. So obviously, stopping a woman who doesn't want to have a child from getting an abortion would be an interference with that right. Now, the way courts deal with abortion cases, because abortion cases involve so many competing interests, is they've basically defaulted to what courts call balancing test, okay, where you know, in analyzing whether a burden on a woman's right to terminate a pregnancy, right, whether that's too much of a burden, you weigh that against the benefit. So if there's some benefit to the law, right, some health benefit to the law, usually that's what courts are looking for, right, you know, does some kind of medical requirement, does that actually cause better medical outcomes, right? If so, maybe the burden is okay. But what they're looking at is the burden on the woman versus the benefit, right, to whatever restriction a state is imposing. And if the burden outweighs the benefit, you know, then presumably it's unconstitutional. But the court has never well defined how that balancing test works. So, you know, it could, I've written about this in a journal for the University of Kansas Law School. You know, sometimes courts apply balancing tests in ways that kind of weight, right, put the thumb on the scale on the side of, right, of one of the sides in the dispute. The current court is probably going to be inclined to put its thumb on the scale, right, in favor of the state. So we're going to find out here soon how the Supreme Court's going to deal with abortion restrictions, because those, in one case, case called Cruzan, the Supreme Court, without explicitly saying that this was a fundamental right, treated it like a fundamental right, and kind of reaffirmed that in a later case called Glucksberg. And that's the right of the individual to refuse unwanted medical treatment. That's going to be a really interesting one if they ever come up with an effective vaccine. Right, to see whether the states or the federal government, right, or local units of government can require vaccination, right, as a condition of going back to school, going back to work, right, you know, working in a place of public accommodation, working in public transit, right. You know, I've heard a public expert opine lately that you know, before anybody goes back to a sporting event, they should be required to, right, have a vaccination card, right. So I mean, this right to refuse unwanted medical treatment is almost certainly going to be another one that's in play, and we'll see whether that gets tweaked, right, in light of recent developments. But that is a right that courts have regarded as fundamental for quite some time. Finally, there's a kind of a complicated topic here, is the right to travel. Congress arguably can interfere with the right to interstate travel, because Congress, as I also discussed in a prior video, has the authority to regulate interstate commerce, but states are not supposed to prohibit interstate travel, right? There is a right to travel implied in the Constitution, according to the Supreme Court. Obviously, we're going to see that tested as well, not just in the course of this pandemic, but if there's another one, right, at any time during our lifetimes, right? Anytime you see the spread of disease in one place, right, the question will be, especially in the absence of effective federal oversight, whether states can act to protect themselves against people coming in from other states, right? So again, there's all kinds of issues. I could do an hour-long video just on that. I won't, I promise. But that's one of the three rights too that I think is going to be, you know, tested. So the 5 rights, the 5 unenumerated rights that probably come through this unscathed: the reproduction, contraceptives, marriage, care, custody, and control of your kids, right, and family living arrangements in the family unit. Those would be rights that I don't see any reason why courts would be messing around with those. 3 to watch out for, if you have an interest in this kind of stuff, would be abortion. What is the court going to do with the abortion balancing test, right? And then will they loosen up the standards on the other 2, which is right to refuse unwanted medical treatment, right? Will they be more permissive, that the government can do that, even though that's a fundamental right? They can require vaccination. By the way, they've upheld compulsory vaccination in other contexts, right? Going to school and things like that. But this is going to be much broader, so we'll see what happens with that. And then the right to travel, right? Do courts take a more deferential view, right, of a state's ability to protect itself, right? And that would include restricting travel into the state in the absence of any kind of really comprehensive federal regulation. So thanks for watching. If you like this stuff, again, please click subscribe and like and all that kind of stuff. And we'll see you again when it's not raining out so hard.